And we begin with that story in the Sawa. Nandipha urgent High Court application has been postponed to the 1st of June. She wants her arrest and deportation from Tanzania declared unlawful. The postponement is to give Home Affairs time to file legal papers. Senior reporter Silindelo Masikane has been on the story and joins us for the very latest on court proceedings earlier this morning. A very good afternoon to you, Slee. For the benefit of our viewers, what exactly was put forward in front of the judge in a court this morning?
Well, really not much. All we saw were legal representatives for Dr. Nandipha as well as the respondents in this matter who told the court that an agreement had been reached in terms of particular dates and times for the legal teams to be able to file responding, or should I say opposing papers to the application that's been brought by Dr. Nandipha here at the Free State High Court. Of course, we know that she wants her arrest in Tanzania to be declared unlawful, as well as her deportation that she has described as an abduction. She says in her papers that she was in fact apprehended by South African police in Arusha and subsequently as well taken to an airport by South African police in uniform to be transported back to South Africa. Now, the contention here is, of course, whether she was legally or illegally deported or extradited from Tanzania. And, of course, we know that the Home Affairs Department, which also brought a legal team to court, will be joined onto the matter as the sixth respondent. But to just unpack a little of what we saw this morning, I am joined by legal expert Ms. Inez Bezaden-Hurt from the Free State University. Thank you so much for your time. Very brief proceedings in court. The judge essentially being told that an agreement had been reached between the legal teams to postpone the hearing. Now, does this matter then remain on the urgent court roll, or are we going to hear it perhaps being transferred in the High Court but to a normal court?
Thank you, Slee. What we saw this morning is what one can expect of an application of this nature. The court enrolled the matter on the opposed roll for next week, also requesting the parties to file their supplementary affidavits or opposing affidavits and then their heads of arguments, which means that we expect that the matter will be heard, the issues properly ventilated in court next week. Then, as a matter of urgency, since it deals with the liberty of a person, one do expect that this matter will be heard in more expeditious fashion, as one would normally find in any other application. However, I do think the matter of urgency will also be an aspect that will have to be addressed by the different parties.
All right. So we're still going to expect arguments around whether this matter is urgent before we deal with the merits of the case, and perhaps then talk to us about what makes an application urgent.
I do think that the court will look at the procedure, how this matter is at court, placed at court, and how the matter will be dealt with. One can also expect that if there's a material dispute of facts, the court will probably or can possibly refer the matter for oral evidence. So that will depend on the court. The High Court has inherent jurisdiction and a wide discretion in terms of how the procedures should be conducted.
Then let's talk about what she says in her papers. You've had a look at her application, her affidavit, and we're essentially talking about extradition and deportation. Does it really matter now that she is actually back in South Africa what happened in Tanzania?
The effect of the differentiation between the different ways in which she could be brought to South Africa will definitely have a bearing on the proceedings in front of court. The ultimate effect of that, if the court would find in favor of the applicants in this matter, is a contentious issue. Would the state be able to merely then just arrest her again? That is a matter that will also have to be properly ventilated in front of court. One can expect that she could possibly be arrested again in South Africa.
And then let's talk about her other relief that she's seeking in terms of legal proceedings against her in the Magistrates Court to also be set aside. Does this court have jurisdiction to do that?
The court has inherent jurisdiction and a wide discretion to decide on the legality or not of any provision in terms of any act. So one expects that the court can set aside the proceedings.
And then the NPA would have to, once more charge her? What would the process be unfolding there?
Yes, indeed so. Then the matter will have to start de novo, and it is within the discretion of the NPA to prosecute or not. Courts barely and rarely interfere with the state's prerogative and choice to prosecute or not.
So quite an interesting case, perhaps, for case law itself.
Absolutely so. It's got a number of issues that will definitely challenge the law as it currently is.
Thank you so much. All right, that is legal expert Sinez Bezuidenhout from the University of the Free State, unpacking what we've seen. Very brief proceedings here in the Free State High Court, but we are expecting to be back here on the 1st of June, that is on Thursday, for the hearing into this matter. There are particular dates and times where the respondents have to have filed their opposing papers by next week, as well as having filed their heads of argument as well. So next week, another, more court proceedings, rather, should I say, that we're expecting, not only in the Magistrates Court, where we're expecting the bail application judgment for the 5 co-accused on Monday, but on Thursday we return back here to hear this application by Magudumana, who says that she's been abducted from Tanzania and brought back into South Africa.